Calling the first case in our list, SJC-11446, Commonwealth v. Wayne C. Tassone.
Yes, counsel. Good morning.
Good morning. I apologize to the court and to Mr. Piropan. There was a big traffic snarl right off the
No problem.
pipe.
Understood. We all deal with it every day.
Well, I pity you. The linchpin of our argument of this case is that Tiffany Roy's testimony, she was the expert, the DNA expert whom the Commonwealth called, admitted information which qualified as testimonial hearsay.
There was no objection, was there?
Well, there was a motion to exclude her testimony, and there was a long, there was an objection. It was before she testified. The judge...
But not at the time she testified?
Not at the time.
And there was no cross-examination of her?
No cross-examination.
And in closing argument, the defense was that the DNA on the eyeglasses was Mr. Tassone's eyeglasses, or Mr. Tassone's DNA, but it doesn't really make any difference because anybody could have worn those glasses or could have brought those glasses to the scene of the crime, and in particular, the defendant's brother with whom he lived had an identical pair of glasses, and he could have worn those. And the defense in this case was identification or misidentification.
Right.
The defendant claimed that it was his brother that committed the robbery.
That's right.
So the DNA evidence was totally consistent with the theory of the defense of misidentification.
Well, it was also totally consistent with the theory of the prosecution. The prosecutor emphasized 3 times in closing that we have a positive match here. We know it was the defendant. So the jury would have had to pick between them. But there was, a huge amount of discussion about whether or not it would come in. I don't think there's a preservation question. Our theory, or my theory, is that the linchpin of Roy's testimony was that the DNA information from the eyeglasses found at the scene had such and such features, which turned out to be the same features as the defendant's, and that the DNA evidence was obtained in a scientifically reliable manner. It's analogous, I think, to a circumstance where if Roy had gotten up and said, I heard from someone who was at the scene identify this person by a very distinctive tattoo or birthmark, and it happens to match the defendant here, so there must be a match. It's one of the difficulties with identification evidence in that kind of situation. But I don't think we could say that in that case, which I think is quite similar, that the out-of-court declaration was not testimonial hearsay. If it came in as a part of a police officer's report, for example, under Davis, I think the case is, I'm pretty sure the Supreme Court would say, no, it wasn't admissible.
What were the details of those analysts' reports that came in?
Well,
other than the fact that they had analyzed the DNA on the eyeglasses and analyzed the known sample from the defendant, other than that, what details came in?
what did Roy testify to?
No. What details from the reports of the DNA analysts came into evidence?
You mean through Roy or otherwise?
I'm sorry, I didn't hear you.
Is the question through Roy or otherwise?
Well, when there were no exhibits. She testified that the eyeglasses went to Cellmark. She didn't use the phrase an allele chart or table, but she explained that there were 16 loci, and they're generated by using a machine, and numerical values are assigned.
But that was a general discussion of how DNA evidence is acquired.
Except it narrowed toward the end of her testimony, where the question was, and did you examine what you received from Cellmark, yes. Did you compare it to what you received from the people in your own lab? Yes.
And what's your opinion?
And well, and the use of phrase, did you form an independent judgment about what it was? And she said yes, that they matched. So
Didn't she also talk about, I put the 16 alleles on the one next to the 16 alleles on the other, and they matched? I mean, she
Well-
mentioned the fact that they each had 16.
yes, it was specific. I mean, she was very specific about it. And she also mentioned it was the, I forget the exact term, a major male profile, I think is the term she used. So there was a lot of evidence. It's clear, it seems to me, that the jury would have known that somewhere out there was a report with these kinds of details on it.
So you're arguing, your concern is that there's, every time there is this kind of testimony without anything else, there has to be an implicit assumption that there was an underlying process, the kind of process I think Justice Kagan was concerned about in her dissent in Williams, I think.
Yes, exactly.
And that, so
And
basically you
it's-
want to revisit that question.
It's analogous to embedded hearsay. I
Right.
want to emphasize it's analogous to, because I think it's a mistake to confuse sort of evidentiary lines of analysis with confrontation clause analysis, because how we sort of got here was that the court said we can't do that. At least that was the theory in Crawford.
What evidence was there that what came back from Cellmark was the alleles with regard to the eyeglasses?
The evidence was Roy's testimony, basically. There were 16 16 numbers, 16 numerals.
But wasn't there
Right.
wasn't there chain of custody evidence also?
Oh, sure. She also testified how they got the, well, Sarti, there was another witness who was the one who did the, got the swab, said, I did the swab, this is how I did it, so forth and so on.
And I sent it to Cellmark.
And then Roy testified, it went to Cellmark, which, of course, the jury had already heard. And they sent me back a report. And based on that report, I reached the conclusion.
But how did they learn that what the report they sent back was the report with regard to the sample that had been sent to them? Was that just
Well,
implicit?
it's from Roy. Roy testified.
So Roy basically said they did a test
Right.
on that, and this is the alleles that they found.
Right.
So that information was provided by Roy, even though she had no personal knowledge of that.
Right. I mean, she was assuming, I mean, she actually didn't even have personal knowledge that had been sent to Cellmark, but that was not in doubt.
Well, I'm sorry, was the chain of custody objected to?
There was no objection to chain of custody, no.
But it sounds like at least the chain of custody getting it to Cellmark was properly done, because that's what the other chemists testified
I'm
to.
not really disputing that. I mean, I think the other analyst, her name was Lynn Sarti, was pretty explicit about it, and there wasn't really, it wasn't argued, there was no dispute.
So your dispute is on the other, is going back and
Coming
this-
back,
and this implicit.
Putting, exactly, the implicit incorporation, if that's the right term, of testimonial hearsay. as the
What
basis
was
for
the
the-
specific objection that had been made earlier?
Well, there were two. One which I waived in the appeals court. One was that at some point Roy had said that she had uploaded information she had into the CODIS database and got a hit. So there was a question, well, were you relying on that or were you relying on something that was legitimate? There really wasn't a question when we finally got through the voir dire that that was a non-issue. But the other aspect was that it was explicitly stated that there's a confrontation clause problem here based on what the report said when it came back from Cellmark. That is testimonial
But
statement.
what was the confrontation clause problem that was identified?
At trial?
At trial. It
In
was-
limine.
I'm sorry?
You said this is all raised in a motion in limine.
Well, there were two motions in limine. The Commonwealth moved to have it admitted. The defense moved to exclude it. It was raised more explicitly in the motion in limine that the defense filed, but it brought in that it was testimonial hearsay, that the Cellmark report would be testimonial hearsay. I'm sorry, have I answered your question, Justice Pena?
Okay, but the report didn't come into evidence.
The report itself did not come into evidence.
Right. So, okay. So what came into evidence? Just her testimony that she
Was her
examined the
testimony
materials?
about what she observed
She examined
She examined this report, and how I got it was this way, blah, blah, blah. And then I examined this other report, which we got from, as a result of a buccal swab taken from Mr. Tassone. I don't think she said after he was arrested, but I mean, that's what happened.
And in her opinion, they...
Her opinion, they matched.
And what was the likelihood of someone other
Didn't
than...
do any of, it wasn't in the usual ratio, percentages, and all that kind of stuff. It was just, they matched. That was her testimony.
And there was no objection to that,
No,
to that particular opinion?
no. All of the objection came in at the end of this long, at the end of the voir dire and this long discussion where the judge went over the case that had just come down was Barbosa, either that day or the day before, just as it happened.
So she just said that these alleles match? She didn't say what the likelihood is of a random match?
It wasn't in the more conventional format.
Did she at least identify that these alleles were specific alleles which were designed to distinguish among human beings as
Well, she
opposed?
did testify that aside from identical twins, everyone, as far as we know, will produce a different allele table. She didn't say that in those words, but that she was saying that.
With regard to these alleles or in general? Because 99.9% of our alleles are going to be the same.
What she said was, aside from identical twins, everyone is different.
But she did talk, I mean, I've got in my head, maybe I'm wrong, that she did actually described, you've got 16 over here and you've got 16 over here. So she's talking about the substance of the reports.
She is,
in some,
yes.
right? It's not just,
It's not
it's my
theoretical.
opinion that they match.
It's not theoretical. She's saying, I compared the document that Cellmark, or the documents, whatever, that Cellmark generated with those that were generated by my own lab. And, you know,
And she talked
when I
about the
ma-
16
When I matched those up,
yeah,
the numbers,
the 16.
matched,
Yeah.
and my conclusion is,
Now, the genetic profiles, the DNA profiles from the swab taken of the eyeglasses and the DNA profile that was generated from the buccal swab taken from the defendant, those DNA profiles were generated by two entirely different labs, right?
that's correct. Well, to answer the question,
It wasn't done, but both of them were not done by Cellmark.
no. The eyeglasses, the swab of the eyeglasses is done by Cellmark. The buccal swab was done by, it doesn't come out at trial.
State
Not at
police
voir
lab.
dire. It comes out by another branch of Miss Roy's office.
By
A
Miss
woman
Montgomery,
A woman
right?
named Montgomery did it. I'm sorry, Justice.
That's just, yeah, I was agreeing. It was Montgomery, right.
Okay. No, completely two different entities. The other point I want to bring up, because whenever one doesn't know how to do it, but I'll try. In Greinider, I hope I'm pronouncing it correctly, the first of the Greinider cases, this court actually said that the report generated by in that case, Cellmark, was in fact testimonial hearsay. In the second Greinider case, it didn't say yes or no, and I didn't know what it meant because Williams had come down in the meantime, whether you were changing your view on that or not. But I thought I'd better bring that up because it's not really clear. One of the problems, because I know that the Commonwealth's argument is that basically we kept the testimony to a minimum. There wasn't any testimony hearsay coming out of Roy and so forth and so on. Which ties into another aspect, which I do want to bring to the court's attention. This idea that if the defendant has some element of self-help, that somehow moderates or changes the picture in some way. I think one has to be very wary of that.
I don't understand what you mean.
Well, if you examine the expert witness, you have a cross-examination expert witness, you
And
can get a
everything's
lot of
fine.
at least theoretical information out there, which can be fairly specific, even if it's theoretical. And that being so, it really can do the defendant a lot of favors. You're not really helpless in this situation.
But that's confrontation. That is what confrontation is. It's cross-examination.
But
Undercutting the testimony, in
That's
this
right.
case, the expert opinion testimony.
But the question is, who has the burden to present it in the first place?
The burden to present what? The
Well, if
cross-examination?
it's testimonial hearsay, which I've been arguing, it falls to the Commonwealth. It wouldn't fall to the defendant to explore it or develop it.
But you're saying here, I take it, that during the direct examination by the Commonwealth of the witness Roy, something came out that shouldn't have come out. Isn't that right?
Well, I'm saying, I think it should have come out because
No,
it was
no, but I'm
testimonial
just-
hearsay. But the question is, whose testimonial hearsay was it? It wasn't Roy's. It was this unknown analyst.
Well, right, but as I understand our opinion in Greineder, I mean, it would be all right for the defendant to bring forward the other analyst's testimony insofar as it would be a basis for the opinion, but not okay for the Commonwealth to bring it forward.
Right,
In the
and
direct, are
I'm
you
saying
saying
that's
that?
a mistaken view of the allocation of burdens of production under the Sixth
I guess what I'm
Amendment.
trying to do is understand what happened here. Are you saying that they did it the wrong way here, even under Greineder, or that they did it the right way
No, I'm not.
under
I'm
Greineder?
saying even though they may have done it according to Greineder, I'm out of time, but basically that in Melendez and in Crawford, it's clear that the defendant does not have a burden of coming forward with any of this if it falls on the Commonwealth to begin with, because it's testimonial hearsay used to prove a fact to be used at trial.
I'm sorry, I just need to ask one question. I thought you were saying, actually, the Commonwealth did not do it in accordance with Greineder in the sense that, because of two reasons. Number one, implicit in her, I mean, it had to be implicit in her opinion testimony was this underlying stuff. And number two, I thought you were saying that, in fact, there was some hearsay that came in, the fact that she got it from Selmark, the fact that they had 16 alleles on, I mean, to some degree she described these reports. I thought that you were saying
Maybe I'm
that.
misunderstanding Greineder. My understanding of Greineder is that there's kind of a cutoff point. There's a minimum that you can bring in, and then if you want to challenge the basis of this defendant, you have the cross-examination available to you. So maybe I'm just misunderstanding Greineder. My argument is that the evidence came in through Roy, and she was not the person who should have been examined at the point.
Thank you, counsel.
Thank you.
I think he's arguing both. If too much came in and we did it wrong, it doesn't, I think he's saying, I think it's just, we're missing each other.
Good morning, Your Honors. Chief Justice Ireland, members of the court. My name is Joseph Piropan, Assistant District Attorney for the Berkshire District. I think, as Mr. Adams pointed out, what the Commonwealth's evidence in Tassone amounted to was a barely minimum, which is far less than that offered in Grenadier. In Grenadier, which was handed down just 11 months ago, the court struggled with the problem that Robin Cotton from Selmark not only testified to her independent analysis or comparison of test data, but she also used charts and graphs and data. And the court found that was impermissibly offered into evidence, but it didn't arise, but wasn't a prejudicial error. Here, I must make it abundantly clear, and I'm sure Mr. Adams would not disagree, there was no data. There was no data.
But
how
that
can there
gets
be an
to the
opinion?
point. Well, you go ahead.
How can there be an opinion without any data?
Oh, you said there was no data presented to the jury.
there's no-
Obviously, the
Right.
expert saw the data.
Well, and exactly, Justice Corey. During the course of the voir dire, chain of custody was established. The fact that reports had been generated and provided, but there was never one specific instance showing 16 loci or alleles given to the jury.
Right, but what did she say she got from Selmark?
On page 62 of volume 3, and I think this is the point that the defense mostly takes contention with. Selmark, I'm quoting, Your Honor, Selmark generated a DNA profile from the eyeglasses. That's it. That's all she said. She did not indicate what the profile was. She did not indicate how many alleles or how many loci or the character and nature of the alleles and loci.
And she also said, and I'm comparing it, so I've got it.
Yes, I got
And how did she know that?
How does she know that?
Yeah.
Because Lynn Sarti had previously testified on the record that she had sent the eyeglasses to Cellmark.
Okay.
Now-
so she effectively is telling the jury, Cellmark did this and produced these alleles with regard to the question sample.
But what she did not say was, unlike in a case like Bullcoming, where the lab says this is cocaine, and yep, I'm looking at it, it's cocaine. There was no underlying basis, no underlying facts, rather, offered of the DNA profile.
Have we ever allowed this testimony to come in without somebody from the lab examining the question sample to testify?
I believe that was the case in Barbosa.
It was not.
was not?
Barbosa had the supervisor. Barbosa expressly says, where an expert survives a Daubert-Lanigan challenge, or whereas here the defendant does not challenge the admissibility of the expert's opinion, the defendant may still, as here, cross-examine the testifying expert as to the risk of evidence being mishandled or mislabeled, or of data being fabricated or manipulated, and as to whether the expert's opinion is vulnerable to these risks. How was this defendant in a position to have that cross-examination where there was nobody from Cellmark testifying?
Well, I think it comes down to a question of whether or not it's a question of admissibility versus a question of confrontation. I think that in the amicus brief filed by the defense, they raised the point that it should not be the defendant's burden to present the underlying analyst who could establish that that indeed was the DNA profile provided to the independent analyst. Here, I think that's the defendant's option to question the reliability of the underlying science.
And how can the person question the reliability when no one from Cellmark is there? The person knew nothing about Cellmark's procedures.
Well, I think that strikes at the heart of what Justice Alito and Justice Breyer spoke to in Williams, in which they indicated that even Justice Kagan pointed out that the analyst could say a sample was provided. What Justice Kagan objected to was the fact that it was a vaginal sample. And so in the footnote in Williams, Justice Alito in Williams deleted the words vaginal swab. Similarly, I think Justice Corey, your concern is the same. The question is, how do we know that that swab came from the eyeglasses?
And now my question is different.
Okay.
In Barbosa, we said there's still an adequate opportunity to cross-examine because the Cellmark supervisor testified. In Greinader, we said there was still a meaningful opportunity to cross-examine because there was somebody from the lab there who knew a good deal about the testing to testify. Here, how is there an adequate or meaningful opportunity to cross-examine when there is nobody from Cellmark on the stand who can say anything as to what Cellmark did?
I think the point is very fine in that in Barbosa, even though the supervisor was the witness was the supervisor, I don't believe that the supervisor had direct personal knowledge as to what sample went into the hopper to come out. I believe that the supervisor could testify to procedures and policies and the fact that he or she had supervised the individual on numerous prior occasions. I do not believe, I still think that you'd still have the same issue of whether or not that person, if they worked for Cellmark, for example, could say, I can assuredly tell the court or the jury that sample came from these eyeglasses. I think that in Grenadier, I may be reading this a bit too liberally, but I'm sure I'll be corrected. The court addressed that fact and said that we do not mean to impose that degree of scrutiny that was requested by the defense along Immuno's line, for example. Strike that. But the point being that it's the cross-examination is to the expert opinion, as to the reliability of the underlying data, as the court noted in Barbosa and is echoed in Grenadier. This is not a case in which we have subjective data. Subjective conclusions like fingerprint data, which can be parroted. The fact is, the data is the data. It is the expert's opinion that says, I see the data, this is what it means. And I think that is the type of cross-examination that is being challenged and being affirmed in Grenadier in terms of what the expert can say. I firmly believe that for admissibility, if the expert says, I have sample A and sample B, and if the expert can indicate on cross-examination, I have no idea where sample A came from, I think that satisfies the confrontation clause.
But when the expert says, I have sample A and I have sample B, and my opinion is they match, at some fundamental level, don't you have to get into evidence, sample A and sample B?
No, they're specifically rejected in the DOIS case. The underlying facts do not have to, shouldn't come in.
But you need something to ground this opinion in something that is before the jury.
Well, and I think that there was sufficient background information in which she indicated this sample A came from the glasses, sample B came from Mr. Tassone. And I think again the court is struggling with the question of, well, how can Ms. Roy testify that sample A is the eyeglass sample when state police, or I'm sorry, the state police laboratory took the swabbing, sent it to Cellmark, it came back from Cellmark. Absolutely nobody from Massachusetts saw the people in Maryland or Texas submit that to a DNA profile test. But I think that begs the question that was addressed in DOIS. We do not allow the underlying data to come in on direct examination.
Let me ask you this. So let's play this out for us. Tell us what we said in Grenadier and Barbosa. How, as a practical matter, does the Commonwealth put this kind of evidence on where you've got two test results, one from the, let's say one from the state lab and one from Cellmark, and you have an expert saying, I've looked at the report from Cellmark, I've looked at the report from the state lab, and there is a DNA match here.
Well, Your Honor, in fact, in my brief, I quote the actual passage from Grenadier, and I'll beg your patience it's only one sentence.
Please.
The prosecutor, as a general matter, may first ask the expert for an opinion, given the expert's background and training, and after review of the underlying data.
Right, stop right there.
Yes.
Opinion of what? Do you have an opinion with respect to what?
Whether the A and B are similar or match.
Is that what the opinion is?
Okay, go on. I'm sorry, I interrupted you. Read that.
Let me finish, and I'll get back to Justice Lange, please. Whether and this is the same sentence, whether the defendant, given his or her DNA profile authenticated by chain of custody evidence as having originated from the defendant, could be excluded as a possible source of DNA recovered from the crime scene, similarly authenticated by chain of custody evidence. That's the narrow holding Grenadier.
Okay.
And I stress to the court that in Tassone, which was tried 3 days after Barbosa was published, the trial judge basically foretold the Grenadier holding and limited the Commonwealth to that very, very brief evidence.
So the predicate leading up to this opinion that either this is a match or this is the likelihood of some person having this sort of incidentally or it's really beyond comprehension is what? What comes into evidence? You've got the chain of custody person who says, I swabbed this, I sent it off to a lab, and it came back.
Basically, yes.
Okay, that's it. And then I swabbed this, I sent it to another lab, it came back. So you have two samples, correct. Presumably. Are the samples in evidence?
No.
Okay.
No. In fact, in this case, Justice Cordy, there were no exhibits offered during the examination of
and then the expert gets up there and says, I have examined the samples that have come back.
No, she just examined the reports, right?
Reports, excuse me, I apologize.
The profiles.
Reports, the profiles
yes.
with respect to the samples.
The samples are meaningless without the profiles.
Okay, I've examined the profiles of the samples that have come back, and I conclude that whatever the expert opinion is. Is that how it works?
And I think that's the very, very straightforward holding in Grenadier.
Well, let's take the Nardi situation, the autopsy.
Yeah.
A doctor performs an autopsy, and the doctor retires or dies. So the report, the autopsy photos, and the toxicology reports are sent to some doctor 10 years later. The pathologist who testifies for the Commonwealth says that the guy who performed the autopsy or the woman who performed the autopsy has died. I have reviewed that person's report. I have reviewed the autopsy photographs. I reviewed the toxicology report. There's nothing in evidence up to that point in time. Doctor, what's your opinion as to the cause of death? The doctor gives the opinion and sits down and gets ready for cross-examination. Isn't that the way it happens?
Yes. In fact, the analogy would be that in Nardi, all would be admissible.
Independently admissible.
All would be except for the conclusion of the deceased medical examiner. For obvious reasons, that would be a hearsay statement. His or her opinion as to cause of death is inadmissible. The test results, the photographs of the autopsy, observations made without commentary as to what may have caused the wounds, the raw data, so to speak, would be independently admissible.
Not admitted, but independment admissible.
That's correct.
The photographs are admitted often.
Not always.
Not always.
They don't have to be.
Not always. But my point here again is that as the court has indicated on several occasions, beginning with Barbosa, and continuing through with the line of cases, including Nardi, cited by Justice Spina, and concluding in Grenadier, in order for expert testimony to be helpful to the jury, admissible even, it is to be pared down in base form so that the underlying data is established only to the degree of what is it? It's a swab, it's a profile. The specific results of the data generally would not be admissible. And as Justice Kagan objected in her plurality opinion in Williams, she was concerned that the fact that the expert in Williams testified to the fact that it was a DNA sample from a vaginal swab. She said everything up to vaginal swab is good. Now here, understandably, nobody from Massachusetts accompanied the eyeglass swab to Cellmark and back. But there was no objection to that either at trial. And I would submit that if the defendant wishes to contest the reliability of the testing, that is an option, but not a burden that the defendant can muster. And I see my time is up, and I'll rest upon my brief.
Thank you.
Thank you very much for your time, Your Honors.